It looks as if the state has waived oral argument on this case, so you will have 15 minutes to argue. We have read the brief, and if you'll give me just one moment to get to the right page. We're ready.
Would the court like me to speak
Just at the podium, please.
Sure. Your Honors, my name is Christina Ryle. I am the appointed counsel for Mr. Justus on the matter before the court today. This particular case involves the trial court's refusal to allow a hearing on a motion to suppress. This motion to suppress was not only it is admitted that this motion to suppress was not filed in that original 35-day time period, or at least 7 days before the bench trial, in one of the two arraignments that was held in Mr. Justus's matter. Mr. Justus was actually charged with OVI. He was charged with 3 different counts initially. That arraignment did go forward on July 7th. They didn't receive discovery until approximately August 7th, which means if they were to file this motion within that 35-day time period, counsel for Mr. Justus would actually have had to file that within 2 business days, because this 8/7, when they received it, was actually on Friday. So Saturday, Sunday, we're assuming he's probably not getting it done. He would have had 2 business days to file it if we're looking at that. He did file it within 2 weeks after that.
But did not file a motion to continue or to extend the time within those 2 days.
Correct. He did not file a request for an extension. Instead, he did try and avail himself of Rule 12D, which does allow you to grant that even without the continuance after the time has expired for good cause. And in this case, his motion did clearly state that he was asking them to take that out of time, even though it was after the 35-day time period, because it had taken a while to get discovery, also because he still had not received a copy of the video from the officer's dash cam. And that would have been very helpful to him to have that before he wanted to put the court through a hearing, because a lot of times as a trial attorney, you get that. Your client may tell you something, but you get that dash cam and you say, are you sure? So it's very, very helpful as a trial attorney to have that in advance so you're not wasting the court's time. In this particular case, the other thing I wanted to point out is there was a 4th charge, a 4th OVI charge, which was related to a BAC level. In this case, that was not filed and was not arraigned until August 18th. And that's the one that he actually pled no contest to, was the one that he was not even arraigned on until August 18th. And this particular motion was filed on August 25th. So I wanted to bring that to the court's attention too, that although, yes, related to the other 3 charges that were brought initially against him, this is out of the 35 days. This is not out of 35 days from that second arraignment, which occurred on the 4th charge, which is the one that he actually was eventually pled no contest to.
So, in light of the fact that that is the charge to which he pled, does that bring us within the time frame?
Unfortunately, it still does not, because even though this 4th charge was not arraigned until the 18th of August, the bench trial was still set with those 3 initial charges for August 31st, which means this motion was still filed only 6 days before the bench trial was set, not 7, which is the requirement of the rule, but he clearly did not have 35 days in that time. He only had 2 weeks basically to file that motion to get it filed before the bench trial from that second arraignment from the charge he actually pled to. I can tell from the state's brief that the state is very, very focused on was this filed in time or not. I found that very interesting because the trial court didn't even address that issue. The trial court instead focused solely on whether or not the facts alleged by this motion to suppress supported even having a hearing. So the trial court didn't say we don't think there's good cause to file late. They didn't look at was this 2-week window, if we're looking at the first 3 charges, was this 2-week window reasonable and we should still say there's good cause to file this late? Or is this related to this charge that he's actually pleading no contest to, and there's good cause to allow him to file basically 1 day late in that one? The trial court didn't even look at that issue. They only said, we're looking at the facts that are alleged in this motion to suppress, and we don't think that based on the facts that are alleged, we should give you a hearing anyway. Because on appeal, we've got to basically overcome both of those hurdles. Not only was there good cause to file this out of time, but also was there a factual basis for the trial court to have required a hearing on this matter. In this
Well, to that point,
yes.
If the court jumped to the second, and if the second element, and if the defense was required to prove both, does it really matter?
It does, because when you review what the court said, if I agreed with the trial court that there wasn't a factual basis and that this should not have a hearing, you're absolutely correct. It's a moot point. There's no point in arguing good cause because you have to have both of them, absolutely. In this case, however, the court made it very clear in their ruling that they just disagreed with the facts that were alleged in the motion to suppress. The court specifically says in paragraph 2 that it is assuming that the affidavit that was filed by the officer, there's always an affidavit of probable cause that was filed. The court basically said, I know you're alleging that he didn't smell of alcohol, that he was being cooperative except for the fact that he didn't want to answer all of the questions. He gave you the registration, he gave you the license, he complied with what Ohio law requires him to do, but then he decided he wasn't going to answer certain questions, and he has a right not to answer questions that are at a point that could incriminate him. He doesn't smell of alcohol. There's a minor traffic violation, and there's an allegation of bloodshot glassy eyes. Those are the only allegations that Mr. Justus and his attorney say are accurate. Mr. Justus specifically said, I didn't smell like alcohol, even though he said I did. I wasn't slurring my speech, even though the affidavit of the officer says that I was slurring my speech. When you come up against something like that, the law also is fairly clear in Ohio that you have to assume that the facts alleged by the defendant, Mr. Justus, are actually true when you're considering should he have a hearing or not. It doesn't mean you have to assume they're true when you get to the hearing, but you have to assume that whatever he's alleging in that motion to suppress is something that he thinks he can support at the hearing. And if what he alleges the facts were could be heard at that hearing, and in that case there would be enough grounds to say no, this officer, all he saw was bloodshot glassy eyes and a minor traffic violation. Oh yeah, and by the way, he was smoking at the time, so it might have something to do with the bloodshot glassy eyes. If those are the only two things that the court believes after hearing the evidence are true, should this officer have been able to get him out of the car and have him do field sobriety tests? In this particular case, the judge basically said, I know that you're saying that I know you're saying that the officer can't prove these things and that Mr. Justus is going to come in and say the officer was incorrect. But I'm just going to believe what the officer said in his affidavit, and I don't care what Mr. Justus tells me now. That's the problem. The problem is she's already assuming that she knows what she would find and who she would believe at the hearing, if there was a hearing, on contested evidence. And that's why in this particular case, there's a problem not only on should she have had a hearing based on the facts, but also on whether or not she should have allowed this to go forward after the deadline under the criminal rules. Any additional questions? I'd be happy to entertain them otherwise.
Apparently.
Very good. Thank you very much.
Thank you for your presentation. We'll take the matter under advisement. We will issue an opinion which will be sent obviously to both sides, and you can check the Supreme Court website in the interim.
Thank you.